One area that I think we can talk about a little bit more in coexistence agreements when people are adopting trademarks. When I was speaking earlier, I was talking about when you run into a reference and your client really wants to use a mark and there's another mark that's out there that's very similar. Some clients just don't want to walk away and they want to try to work something out. So you can go down that road, but this is one of these areas where it's good to paper over your file very well when you get into one of these things, because generally you do not know. You can do an investigation of someone to find out what they're really doing in the marketplace, and you can get a feel, and the internet's great for that. Oftentimes people have websites and you can learn about them, but you do not know what type of person they're going to be, how interested they are in this possibility of a coexistence agreement until you actually get on the phone with them. And what the purpose of a coexistence agreement is to enter into this agreement where the parties say we can coexist in the marketplace with our two marks and there's not going to be likelihood of confusion. And generally what you do is you put sort of restrictions on each party in the agreement so that they'll sort of stay off of each other's territory. Or maybe this is where you would start using logos and other indicia associated, maybe colors and type styles, to differentiate your marks. And you would agree that maybe I'm going to be in this one group of stores and you're going to be in that other group of stores. Generally, you have to write a check to get one of these accomplished, because most people pick up the phone who have an established trademark and somebody says, I'd like to enter into a coexistence agreement. Their next question is, what's in it for me? And that should be a question. And if you have a client that gets approached for a coexistence agreement, you should definitely be thinking about getting some money paid to them, because it's a hassle and they are somewhat compromising their rights. But we spend a lot of time, because it is such a crowded marketplace these days. It's hardly anymore when we go to search a mark. The question is not, is there a problem? It's how many problems are there, and are they problems that we might be able to work out? But let me give you a warning about these agreements, and that is that if you approach someone and they say, you know what, I don't want to enter into this agreement, I'm not interested, I think it might compromise my rights, or they might come back and say, sure, I'll do this, and I want $150,000, and your client doesn't think it's worth $150,000, and rarely should it be worth $150,000 to do one of these things. You've got to be prepared with your client to walk away from that mark, because once you go to someone to enter into one of these agreements, it can be used as an admission against you if you go ahead anyway and say, well, you know, we thought about it some more, we think we can coexist with you anyway, and then you go ahead and you go over in spite of the concern they've raised. There are some exceptions to this. Occasionally courts will say they were just trying to be, the person who made the approach was trying to be careful, but you should prepare your client. The other reason for it, there's a lot of psychology involved in these things, and it's always nice to say to the other person when they say they want $150,000 and you don't know if this is really just their starting point, and they'll end up at $10,000 or $20,000, which is oftentimes a much more reasonable number to expect to pay if this is just a bargaining ploy or if this is for real. And if you have a backup mark in your pocket and you've convinced your client that they've got to go forward with another mark if this doesn't work out, it can make you feel much more comfortable when you're negotiating, because you know if this deal falls apart, you have another brand that you can use. The worst thing to do is to go to the 11th hour, and anybody in here that I'm sure that's run into this with a client where no one thinks about trademarks, if they're clear, if they're problems. Oftentimes until 2 weeks before the television show is airing, or a little bit before an advertising campaign comes out, or sometimes it's a little too late in the case of Crunch Olympics. You've got to really not let the other side know that you're at the 11th hour, because then they're really going to try to hold you up. But we spend a lot of time working on these coexistence agreements.
Let me just make a comment about that too. Coexistence agreements are also used frequently if there's a blocking application or registration at the USPTO, and people think that if they get the coexistence agreement, then the examining attorney at the USPTO will allow your application to register, but the USPTO does not have to accept a coexistence agreement or a consent agreement. They decide whether they still believe there's a likelihood of confusion. So it's important actually how you frame the words and whether you actually have a persuasive reason why there's no likelihood of confusion. If you simply, ape these words, we agree there's no likelihood of confusion, but the examining attorney doesn't really see any way around it, then that may not be accepted. Kelly, I'm just wondering, do you have, and then I'll get to your question, do you have instances where you enter into business transactions with infringers instead of making them stop so you become a licensor to their activity?
We have done that in the past. I would say that is the vast minority of the cases, but there have been times when we have done that, yes.
And Phil, what's your experience with this type of thing?
One of the things that you should do, and usually these coexistence agreements, or many times, will come up in the context of an opposition or cancellation proceeding in the trademark office. What you should do is make if you're in the dominant position, you should make it contingent on the approval by the examiner when you go back. Frequently, what happens is an applicant applies for registration. The examiner cites your client's application, or more likely registration. So then a procedure is begun to try to eliminate it, and then you negotiate the settlement with a coexistence agreement, saying, all right, we'll both exist. Always make that contingent on getting the successful result for your client. Otherwise, you can find yourself without an ability to stop the other side.
That's true.